this section, we will be discussing Packet 2. Packet 2 involves those cases where people are seeking divorce and there are minor children of the marriage, where we will have to consider time sharing and parental responsibility. If you have no children and you have property, you will be using Packet 3, so you will not be needing this video. Or if you have no children and no property, you will be doing Packet 4, so you will go look for those videos. So for those of you that have children and you want to discuss parenting plan and issues that involve children, we'll be going over this packet. And so you can see the title of the packet says Dissolution of Marriage Forms, packet number 2, Minor Children of the Marriage. And the first page includes a list of the forms that are included in this packet. 1 is the petition, 2 the UCCJEA, notice of filing of child support guideline worksheet, a marital settlement agreement, and the final judgment. And finally, the parenting plan. The last 3 documents or forms are there for your use and are not mandatory documents. So just to be aware, 1, 2, and 3 are the important ones that you need to fill out. However, I will go over each of the forms and explain to you why they are necessary and whether you should bring it to the court or file it with the court. All right, so we will move forward. Petition for dissolution of marriage. We have 1, 2, 3, 4, 5 pages of instructions. And as I mentioned earlier, and when we were going over packet 1, the instructions are there for your use. We won't be going over them or reviewing them only because I will be summarizing what's included in the instructions. Those are there for you to use if after we've gone over all the form you need some clarification and you have a question, you could use those. However, once you completed all the form, you will no longer need them and you do not have to file them with the clerk of court. So you're only filing the actual forms. Okay, so to begin, we have the petition for dissolution of marriage with dependent or minor children. And this case involves where you have children common to you both, you and your spouse, that you will have to include in the dissolution of action. If you have children that are not common to you both and were conceived or born outside of the marriage, they may not be included in this marriage, in this divorce action. However, there's a little caveat which we'll go over when we discuss children of the marriage. So what you will do is fill out the top as usual, including all the information regarding the petitioner respondent, the court, and everything else that we went over when we were doing packet 1. As I mentioned in packet 1, all the forms that you file with the court will include this top case style. So you have to make sure it's consistent. So the title of this document is the petition for dissolution of marriage. And the petition is the actual form that you use to quote unquote petition the court. You're petitioning to the court to take some action. So you're asking the court to do something for you. And in this instance, grant you the divorce. So we'll begin and I will go over each of the numbered sections. The first is you as the petitioner have to write your full legal name because you're the one requesting the divorce. Number 1 includes jurisdiction and residence. And as I mentioned in packet 1, either of you have to have been a resident of the state of Florida for at least 6 months, as well as the children of the marriage should have been a resident of the state of Florida for the 6 months. And in this instance, you could both be a resident or you just yourself or the respondent. So as long as one of you is a resident, the court has jurisdiction. And in the beginning, I was talking about jurisdiction and I briefly covered it. But jurisdiction gives the court authority or power over the person and or the action to grant what you're seeking. And the court cannot have jurisdiction unless and until 1, you meet the residency requirement, 2, and then you meet the notice requirement, which we will go over later when we do the service of process section. So you have to let the court know you have jurisdiction over the person, so you have to be a resident. And 2 is a summary of the military service, so you have to let the court know whether either of you are or are not in the military, so you will check whatever applies to your situation. Number 3 is about the marriage history. You're going to include the date of marriage, date of separation, and place of marriage. Date of marriage is the date you got married. That's pretty simple. Date of separation may be a little awkward because this is the date that you may have separated, i.e., he moved out or she moved out or you moved out. That's the date that you want to use. And the only reason why this is necessary is when we discuss assets and liabilities that may come into play. Because in the state of Florida, there's no such thing as legal separation. However, the date of separation may be used as a basis to determine whether an asset is a marital asset or not. So that may come into play. And I say may because it's ultimately up to the court whether it is determined to be marital liability or marital assets or liability. And place of marriage is where you got married, county, state, or country. You could write city and state as well. It's not as important as the date of marriage. Number 4, dependent or minor children. And this is important because you have to verify which children are of the marriage. And you're going to write, is the petitioner pregnant? If the petitioner is the wife, then you have to write whether they're pregnant and if the baby is due. And then if the respondent is the wife, then whether their baby is due. And then you're going to list all the children that are common to both parents. And in this instance, you're not going to write their full name. All you're going to do is their initials and the year of their birth. So you'll write, if it's Jane Doe, you'll write J period D period and the year they were born, 2014. You don't have to write the date and the month and the date, just the year. And that's just for confidentiality purposes. And you will write for each of the children that are common to both during the marriage. Common means the respondent and the petitioner are the parents, biological parents. And the next section talks about any child that is not common to both. This is if the wife conceived the child with another man. You'll have to write, again, their initials and the date of birth because it may involve them not being determined to be the father is not the legal father or the biological father, and that affects time sharing as well as child support. So you have to list that. And also, who are the birth parents of that child? So if you have a different man or a different woman, you want to list that. And then E talks about any children that are over 18 but that are dependent. Usually this is because they're either mental or physically disabled and they're required to be taken care of by a parent. And you will list the initials and the date of their year of birth. So you will write that. And 5 says family law financial affidavit will be filed, or actually is filed with this petition because it is included in the packet 1 and you're going to file it together. And a completed Uniform Child Custody Jurisdiction Enforcement Act affidavit must be attached. And that's the next form that we're going to go over, so you will be completing that. And 7 is just letting the court know you're filing a notice of Social Security number, which we completed in packet 1, so it should be included. Number 8 is where the important section is. This is where you're actually saying, court, I want a divorce and why. So you have to choose one, and I would say majority of the time, 99.999% of the time, it is because marriage is irretrievably broken. But sometimes, in certain instances, you may be able to check B, and in this instance, the other person has to have been mentally incapacitated for 3 years, and you would need a court order saying that that person is incapacitated. And that is very rare, but it does happen, and usually it's the court says incapacitated. Just because you think they may not have the mental capacity, this is not a reason that you could use. You have to have a court order. So going back to marriage is irretrievably broken, the Florida is a no-fault divorce. So you could seek a divorce for any reason. You don't have to have a basis. Basically, it allows you to file a divorce because you no longer want to be married. And in this instance, I would say majority of the time you would be checking A, i.e. we don't want to be married anymore. So that's the initial section. So section 1 is talking about marital assets and liabilities. Remember when we were filling out the financial affidavit, we had to list all the marital assets and non-marital assets? This is where you're going to discuss whether and if you are going to divide assets and liability. If you check 1, you are basically saying there are no assets and liabilities, meaning we don't have anything that we accumulated during the marriage. so we're not going to divide it now. Or we may have assets and liabilities, but we don't need any help in dividing it. I'm keeping mine, he or she is keeping theirs, so we're not going to divide it. That's when you would check 1. However, if you're having a dispute as to who gets what, then you're going to be going through section 2, number 2. And number 2 is saying we have assets and liabilities and we need to divide them. So how are you going to divide them? There's 2 ways to divide. One is through a marital settlement agreement, which we'll have a sample of later on in this video. Or 2, you're going to say, we can't agree, so we're going to let the judge decide. So if you do agree, you have to fill out the marital settlement agreement, and you have to make sure that you both sign it, meaning it is not an agreement unless and until you both agree. So if you can't agree, you will not be signing the marital settlement agreement. But if you do agree, then you will use that agreement and you will attach it to your petition, so then the court knows that you reached an agreement. So let's say you can't agree, so then you would have to check B, meaning I want the court to decide how to divide the property. And what would happen in that instance is you would most likely have to go to trial, and the court will listen to all the evidence and then determine, the court should determine how the assets and liability are going to be distributed. And then the court will look at all the evidence you present and the other party presents and determine who gets what. And C is basically you saying, I understand we can agree, but I should get this, he or she should get that, and why. So you have to explain how and why you're going to divide it. So you have to be prepared to make that argument saying, I'm entitled to the house because X, Y, and Z. I should get this car because X, Y, and Z. So that's what you want to explain and see, and then the court will ultimately decide. So that's assets and liability. So next section is spousal support. And this is important because this involves alimony. If you are seeking alimony, you have to ask for it. If you don't ask for it and you give up your right or waive it, you could never come back in the future and ask for it again. So if you say, you know what, I'm going to forever give up my right, check here, giving up my right to spousal support or alimony, you can't come back a year from now and say, oh, look, my ex is making $1 million a year, I should get some of it. The court would be like, nope, you already gave it up. However, if you think you're entitled to it, you're going to have to check 2 and say why. So there are different types of alimonies, and you have to meet 3 criteria to be even considered. And then if the court is going to consider it, they have a statutory questions that they have to go through, and it's all based on statute. But the 3 basic things that has to be there before even the court considers it is 1, whether you, the person requesting the alimony, has the need, meaning I have the financial need, I need that money to survive. 2, the person that's going to pay the alimony has the ability to pay, meaning they have that money, extra money, and they could afford to pay you. And 3, the marriage has to have been a certain duration. And there's 3 different types of duration of marriage. 1 is short-term duration, 2 is mid-term duration, 3 is long-term duration. Those 3 different types of marriages depend on or impact if you are entitled to alimony. I'm not saying you'll never get alimony, but you have to have certain criteria before the judge even consider it. I would say, in my experience, if you have a short-term marriage, 1 to 7 years, you may not be entitled to alimony. But I'm not saying never, you may. It's a big may because it's ultimately up to the court. Midterm is from 7 to 17 years, and you will most likely get alimony if, again, you meet the criteria of the need, ability to pay, and the duration of the marriage. And finally, long-term or long duration is 17 and over. And those are more likely to get it than any other terms, only because the marriage has been longer. But again, even if you are been married for 30 years, if the court finds, 1, you don't have a need, and 2, he or she doesn't have the ability to pay, the court may not grant alimony. Again, it's all based on case-to-case situation. So you have to make that argument. So you're going to have to let the court know, I should get X, Y, and Z because X, Y, and Z. And there are all these different types of alimony. There's temporary, permanent, bridge the gap, durational, rehabilitative, or lump sum. And all of these have different criteria. So temporary is only for a short period of time, usually for while the divorce action is going through. Permanent is as it sounds, for the rest of your life. Bridge the gap is for a short distance between point A, getting from point A to point B while after the divorce. So you want to bridge the gap between being married and being divorced. Durational is for a certain period of time, maybe 5 years, maybe 10 years. Rehabilitative is just for the purpose of you getting back on your feet. Maybe you want to go to school. Maybe you're going to get a bachelor's degree, some technical school, and you need rehabilitative alimony, then the court may grant that. And finally, lump sum is basically one big chunk of money. It's usually used as a form of negotiation. Rather than saying, pay me $100 a month for the rest of your life, you could ask for maybe $10,000, $20,000 now, and you don't have to pay me ever again. The issue with alimony is once you give it up, you can never ask for it. However, if you ask for it and the court grants you a short amount of money, let's say right now he could only afford, or he or she could only afford to pay or have the ability to pay only $100 a month, but maybe 3-4 years from now he gets a better paying job and he could afford to pay a lot more. You, as the person receiving the alimony, can go back to the court and argue that there's been what we call substantial change in circumstances, so you're entitled to more. Again, this is all based on what your financial situation is and his or her financial situation is, and the court will take evidence and decide on that. So if you do receive alimony, then you got to consider number 3, whether the paying or receiving alimony has any tax consequences. So if you're receiving alimony, oftentimes it may be considered income. So, and then if the other person is paying it, it may be considered a deduction. So how is that going to impact you? Can you agree that, you only pay a certain amount and you use different ways to give you that money rather than calling it alimony because of the tax consequences? Is something to consider. Also, if you think it's going to impact your income taxes or the amount of taxes you pay, you may want to consult a tax attorney or a CPA to guide you, because I can't provide that guidance for you. Just something to consider. All right, so then you've requested alimony. You could also, in number 4, request a life insurance be placed on the person paying the alimony, so that if anything happens to that person, let's say for instance if they pass away and they're supposed to be paying you $500 a month, if they pass away, they're no longer required to pay the alimony, so you are losing that money. So if they have a life insurance for the amount of money that they pay you, then and you're listed as a beneficiary, it makes up for the money that you should have been receiving. But you have to consider that the court is going to give a reasonable amount of life insurance. So if you're only receiving $100 a month, the life insurance policy most likely won't be for $1 million, just to let you know. So it's something reasonable, and the court may allow that to happen just to protect you. So that's alimony, assets, and liability. The next section is more specific to you as parents of minor children that are involved in the divorce. And this is important because it involves parenting plan, parental responsibility, and time sharing. And parental responsibility is a little bit different than time sharing. And parenting plan is basically a plan that encompasses both. And there's a sample parenting plan at the end of the document, which I'll go over with you, which you can provide to the court as a sample of what you're seeking. And it's very important because when the Florida statute changed in 2008 to establish parental responsibility and time sharing, they made it more holistic, so that there is this what we call a quote-unquote plan, a written plan, so that each party has a copy of it so they know how to treat time sharing with the kids. And time sharing is basically what it sounds like. How amount of time you're spending with each of the children or a child, or each parent is spending with the child or children. Parental responsibility, on the other hand, has to do with who gets to decide what the child does. And usually it involves whether what school they're going to go to, what extracurricular activity they're going to go, what doctor do they see, who gets to decide whether the kid gets braces, who gets to decide what church they go to, things like that. That's what parental responsibility is. And it's two separate but interconnected things. You may have parental responsibility, but you might not have time sharing. Or you might have time sharing, but you might not have parental responsibility. So it is interconnected, yet it could be considered something separate. So we're going to go over each of the required information that the court needs. Number one, it says, where are the children currently residing? Are they with the petitioner, respondent, or someone else? If they're with someone else, you have to explain why they're with that other party. Oftentimes, that other party is because if the Department of Children and Families are involved and they've been removed. Otherwise, they should either be with the petitioner, respondent, or both. And number two is parental responsibility. As I said, parental responsibility has to do with how and who gets to make decisions regarding what the child is going to do. And you can only choose one. So you have to choose either. A is you have to share both, meaning each parent has a right to be involved in the children's lives, and you get to make decisions together. Or B, you could have it solely as to one person. And solely as to one person means that the other parent cannot make a determination, and it would be, quote, detrimental to the children. And you have to explain why. And I would say majority of the time the court will grant shared, because even the court may say, you know what, you can't have time with them because you live far away or things like that, but the court may still provide shared parental responsibility. So you have to look that into it. However, you could also say no, they should not have parental responsibility because they have not been able to take care of the children. And I would say oftentimes this is when there's issues of drug use, domestic violence, things like that. So it's up to you how you choose it, but you have to consider what's in the best interest of the children. Best interest of the children. And that's what's important. It doesn't matter what you want. It matters what is the best for the children. So you have to think of that. It's the same thing when you come up with a parenting plan and time sharing. It also determines what's best interest of the children. And this is a little bit of a summary, but the parenting plan is more detailed, and I will go over that more. But at this point, what you have to do is you have to come up with a plan. You could either agree, both of you agree on a document, the parenting plan, and sign it together and submit it with the marital settlement agreement, or you as the petitioner can request the court establish parenting plan that you want. So you're going to have to decide who is the person that is going to be designated as what we call primary and secondary. And the primary is the person that is going to be spending most of the time with the children. Secondary is the person that is going to be spending less time. Sometimes you could do 50-50, so there is no primary or secondary. So it's ultimately up to you and or the court. So what you're going to do, you as the petitioner, especially if the other party is not willing to agree, you're going to write what you're requesting. So if you look at this section, it says choose only one. So you're going to attach a parenting plan because you have agreed or have not agreed. So if you have agreed, it makes it easy for the court. But if you have not agreed, you have to go into all the remainder of the section. So you're going to submit what you want if the other party doesn't agree and say why. So you're going to say how the time sharing is going to be with each parent and why. And you're going to say with the mother Monday through Friday, dad Saturday, Sunday, and return Monday, etc. And this is just a summary. As I mentioned, the actual parenting plan is a little bit more detailed, and we'll go over that in a second. And then you're going to do C is you're going to explain why. You're going to either have no time sharing, limited, supervised with a third party. And this is very important if you have a legitimate basis to limit contact with the child. And legitimate basis means you have to have evidence that one, the other parent's contact with that child would be what we call detrimental or harmful. So why are you going, what do you need? You need either proof that the other parent is will cannot make decision, or if they're on drugs, if they're alcoholic, if they're abusive, things like that. Those are some of the things that the court may look at. So if you feel that their contact with your children is going to be harmful, this is when you will ask this type of limitation. And number 4 says explain why it is in the best interest. So explain why you think it's in the best interest that contact with the other parent be limited. Again, best interest of the children, not what you want, but why you think it's best for the children. So you have to explain that. Okay? So next section, child support. Child support is also important because if the children, through divorce, the children's time obviously is going to be split. So court will order financial support of the children for the parent that requires it. And again, this is for the children, not for you. So you could usually, if the time sharing is 50-50, you may, and I say may, be able to say, you know, because it's 50-50, the amount of money we make is about the same. Maybe we could say we don't have to pay each other money. However, that's ultimately up to court to decide. But if you agree on it, I would say majority of the time court will agree with what you agree to. However, because this is for the benefit of the child, you can't waive alimony. You have to say, we need this money to survive, i.e. to support the child, pay for their life, basically. And so you're going to say whether you're going to request it, and we have to fill out a child support guidelines worksheet. And this is something that has to be filed, meaning it will be required. So I would suggest you file it with the court. And there's a sample of it attached here, so we will go over it, and it should be attached if you're going to seek child support. And so you're going to write the data set, how or when, if there is retroactive, meaning if you have been separated for a while and he or she has not been paying for the support of the child, you could always have it from the date of separation. As I mentioned, remember earlier, that's when the date of separation becomes important, or the date of filing of the petition, or from a specific date that you've determined was when you need the amount paid. And then you could also request child support be paid beyond the age of 18. This is usually because the child will be in school. If they turn 18 while they're in high school, they could receive financial child support for beyond 18, or if the other child is mentally or physically incapacitated. Those two are the only times you could go beyond 18. And the next one is number 3. You could always seek what we call a motion to deviate. And what that means is the court can move up or you can move down the actual child support guidelines. And I will explain the guidelines when we get to the child support worksheet later, because it's very based on statutory. And once you determine who is paying child support and the amount, then you're going to have to decide what happens with any medical things. Who's going to pay for the medical insurance? You have to decide, respondent or petitioner. And who files for the forms and all the required information. Number 5 is about medical or dental expenses. Those are expenses that are out of pocket. So how do you do it? If it is not covered in the insurance, who's going to pay? I would say majority of the time it's C, where you split 50-50. One parent pay half, the other parent, unless you want to agree to a different, one party pays and the other party doesn't. So it's up to you what you decide, but I would say it's usually divided equally. So next section is number 6. Just like when we were talking about alimony, you could get life insurance. You could also get life insurance for the protection of child support. Again, if the parent passes away, that child support responsibility ends. So they will no longer be receiving child support. So you could ask for insurance to cover the amount of child support. And section 5 is other. This is anything else that you want the court to consider. And for the ladies that have been married and they changed their name when they got married, you could use this section, number 1, to have your name changed back to your maiden name. And this is one opportunity that you may not have any other time. Just like although when you got married, it was easy to change your name. To change your name back, you have to get a court order. And through the divorce action, you could get a court order that says you could change your name back to your maiden name. If you choose not to do it now and decide maybe 3-4 years from later, you're like, you know what, I really should have changed my name. Now I want to go change it to my maiden name. In that instance, you have to go back to court, meaning you have to file a separate court action for a name change, and that costs money. So you have to consider, if you think you may want to change it, you could do it now and hold on to the court order and not use it. To change your name through your DMV, you have to take this court order and go and have it changed. But if you choose not to do it right now, you could keep your DMV or your driver's license the same until you choose to do it. So it's ultimately up to you what you decide. And number 2 is anything else that was not discussed of. Usually I give an example of pets. If you have pets and you can't agree on who's going to get time with the other one, unfortunately pets are not considered children, so they don't determine visitation custody. So you could include it here because although they are quote unquote property, they're not assets or liabilities, so you could ask for it here. If you don't care, then you don't have to list anything. And finally, request. This is a summary of everything you've asked for. So you're going to check whatever applies here. So if you've asked for distribution of assets, spousal support, parenting plan, etc., this is where you will check whatever that applies. And it says indicate, check all that applies. So once you have gotten that done, you're going to sign it and get it notarized. So once you get that notarized, you're done with that form. So the next form we have is the Uniform Child Custody Jurisdiction and Enforcement Act. And we're going to go through the instructions that you don't need right now. I'm just going to slide through them and go over to the actual form. Here it is. And this form is unique to people with minor children. And uniform means it's uniform in all 50 states. And this is a form that anybody seeking a divorce in any of the states in the United States has to fill out, because there's a law that goes together with this Jurisdiction and Enforcement Act that says wherever the divorce is filed, wherever the people have residence, or we call home state, that's the court that has jurisdiction over the child. So if you have children in the state of Florida, you've lived here for more than 6 months, Florida is considered the home state. So you could file the divorce here. So Florida has jurisdiction over. So if you choose, let's say your husband wants to, or your wife moves to Georgia and says, you know what, I don't like what the Florida court did, so I'm going to go file it in Georgia and see maybe the Georgia court will give me what I want. You can't do that, because if you file it in Georgia, you also have to file this court to say in Georgia, hey, the children have lived in Georgia, so they have jurisdiction, which he can't prove. And it's an affidavit, which is basically you're saying under oath everything I say in this form is true. And if you are misrepresent facts here, you may be held in contempt. So we're going to fill this form out. And this is required for all the kids that are of the marriage under the age of 18. So you'll fill out the top as usual, and you, the person that's seeking the divorce, has to fill it out with your legal name. And then you're going to list the number of children that are common, that are involved in the divorce. So you will write, if you have 2 kids, 3 kids, you're going to do that. And you have to fill out a box of this section for each of the children that you have. So if you have 1 child, you just fill out 1. If you have 2, there's 2 extra boxes in the next pages that you need to fill out. So in this instance, you're going to write their full legal name. Although when we were doing the notice of social security number and the petition, we only included their initials, here you have to write their full legal name, their place of birth, their full date of birth, and their gender, male, female. And you're going to list where they have resided in the past 5 years, and the address, name, and the current address the child is living with, and their relationship. So if they've been living with you, let's say the child is 2 years old, so you're going to write their date of birth to present, the address, wherever they've lived, with the person that they've lived with, you and your husband, list that, and mother and father. So you have to do that for the past 5 years. If you've moved, then you have to write each time you moved and the address and whom they've resided with. So you do that for your one child. There's an extra box for the second, third. If you need additional, you can make copies and attach it if you have more than 3 kids. So once you've included all that information, then you're going to write, is there anyone else that needs to be involved in the time sharing? Generally, I would say no. So you're going to write, I have not participated in a party. So you haven't filed anything anywhere else involving the children. So you would choose that. However, let's say maybe you were living in Georgia for a couple months and DCF came involved. So then you'll have to include that in there. If not, I would say 90% of 99% of the time, most people have not. Anything else regarding custody or time sharing? You have no information, meaning this is the first time you're filing it. Again, if your husband was moving or your wife had moved to Georgia and tried to get that file it there, then they would have to fill this section out and say, you know what, there's something going on in Florida. And this is to let the court know so that there's no conflicting orders. So the next page, and any other party involved. Do you know any person that should be involved? Usually this would be if there's DCF involved or if there's any other custody orders, things like that. But I would say majority of the time, no. So, it depends on what your situation in it, and check that. And child support. This is also important because you may have filed for child support while you were separated. If you have, then you have to let the court know, and it sort of saves you some time because then you don't have to fill out a separate child support guidelines worksheet. But if you haven't, you're going to check 1. If you have, check 2. And it's ultimately up to you, and you have to write what type of court and how much they've ordered. Okay? And then here it says you're acknowledging that you're going to let the court know if anything changes. And then you've also completed a notice of confidential information previously. So in this one, you have to notarize, and you have to include the other party, and you're going to have to notarize it. So don't sign it right now. So you finish that, and the petition. So this next form is very important. Let's say you don't have any child support orders and you didn't seek child support, but now through the divorce you want to seek child support, or you have to seek it because there are minor children and you have to file for child support. This is what you need to complete. This is the Notice of Filing Child Support Guidelines Worksheet. This is just a form that you attach to the Child Support Guidelines Worksheet. And this is a worksheet, and the previous form is just a notice saying, I am filing this form. And you would attach it to this notice. And you have to send a copy to the other party, and you can sign it. It doesn't have to be notarized. So you're basically saying, I am attaching this form to that notice, and I'm giving a copy to the other party. This is a very difficult point that we're going to come to. Child Support Guideline Worksheet is very complicated. This form makes it look simple. It's all boxes and information that you have to include. However, it's very complex because what this form doesn't tell you is you have to get your net income, and the other party's net income, meaning you have to know the income of yours and the other person. Net means after taxes. So what you do is you write the father's income, the mother's income. So let's say the father makes $1,000 a month, the mother makes $800 a month. So you have to write that, that's after taxes, and the total is $1,800. And then you have to list how many children you have. So depending on how many children you have, this amount will be different. So what happens is you get your income, the other person's income, you come up with a total, then you have to go to the statute and look for a list that lists all the income, and it has a number. It says $1,800. It has a table for 1 child, table for 2 child, table for 3 child, and that includes the amount of child support the statute or the court or the legislature has decided is for the benefit of the child. That is very difficult because right now, as you can see, you don't have access to it. You'd have to go back to the either the paper statute or go on the website and look for it. So my recommendation would be to go to the website and look it up. And there's also a form, online form that you could fill out, which will do all this for you simply just by plugging in numbers. Once you get, if you look at it, once you get that information, you have to find out divided how many percentage is the father responsible for, how many percentage is the mother responsible for. So you take that total 1800, you divide it by the number of the amount, and you come up with a that's, I know I went to law school, so I didn't have to do math, but this is very complex. So I highly recommend you to do the online form. So once you get that, you come up with a basic income requirement for each parent. And so that's what you will list. And you get some deductions. So if you pay healthcare insurance, you get a deduction. If you have childcare costs, you get a deduction. So you get all that, and then you come up with a figure at the end. So because it is very complex, my recommendation will be to use the website. And the website is www.flcourts.org. You would go to the Family Law Forms section, and when you click on that, you will come up with Child Support Guidelines Worksheet. What you need to do is search for Child Support Guidelines Worksheet, and you could do online worksheet. And if you click on it, it'll come up with this form online. You plug in the numbers, and it will calculate all the numbers for you. And if you need that information, I will provide that for you later, written down. But you would have to get that information, and otherwise you would have to do all this. And there's two different types of worksheets that you could do. One, based on just purely numbers. Second, based on the number of days the child spends with each parent. And that is very complex. So I highly recommend you to use the online. However, if you feel confident, you could use that form and do it yourself. All right. So once you get that and finish all that, if you have not previously found it, you have to attach it with the notice. And you could also seek whether you're seeking a deviation or not. Deviation is usually 5% up or 5% down. And I would say majority of the time the court doesn't grant it unless there's some extraordinary circumstances that require deviation. So you could always say, I'm entitled to 5% more because I'm paying more for this. He's not paying any of that. Or generally, you should not request a deviation, but it's ultimately up to you. So you could decide what you want to do. So you could fill out this form on your own or do the one online. And once you complete that form, it will print out looking almost identical to this form. And you could just print a copy and attach it to the notice of filing, which will save you a lot of time. I'm telling you from experience that it will take you a lot of time. So you do that. So you finish the petition and you finish the child support guidelines. The rest of these forms are for your benefit. They're not required forms. And the reason why they're not required is you will only use it if you can use it. And this is a marital settlement agreement for dissolution of marriage. And as I mentioned earlier, marital settlement agreement is if you both agree to the terms of the dissolution. And if you look at it, I'm going to just go through it with you just to show you what it involves. You will fill out the top as usual. Again, if you think you're both going to agree to it, you could use this form. If you're not going to agree to it, don't use it. Just to let you know, because you don't need it. If you're not going to sign, if you're both not going to sign it, don't use it. So as you see here, it says we're both agreeing. We, the petitioner and the respondent, have agreed to the following. So you're saying we're going to agree to the divorce. And you're going to agree how the assets are going to be divided. The petitioner is going to receive X, Y, and Z. The respondent is going to receive X, Y, and Z in assets. The spouse, the petitioner is going to pay these debts. And the respondent is going to pay these debts. So you have to agree to all these terms. And what's going to happen with designation of, if you require assets and beneficiary, alimony. I agree to all this alimony, who's going to pay, or both of you are waiving it. So you have to agree to that. Parenting plan. How are you going to agree to it? Are you going to attach the parenting plan? That's what you would need to do if you're going to sign a marital agreement, because you're going to say, we agreed to the divorce and this is the parenting plan that we're both going to follow. Child support. You're going to have to decide how much child support, who's going to pay what, how is it going to be paid. So you have to agree to that. And if there's going to be retroactive, meaning is there any past child support that you want to pay? Who's going to pay the health insurance? How's that going to? Dental insurance, life insurance, all that fun stuff. You're going to have to agree, and you sign it. And then the second page, he or she signs it, and you have to both sign it to be effective. If only one of you sign it, it's not effective. So you have to consider that for the agreement. All right. So if you choose to reach an agreement, what would happen is the court will have a hearing, and you will basically present all the paperwork saying we've agreed to X, Y, and Z. And the court will be, okay, do you agree to this? And you both say yes. Then the court will issue the final judgment. Final judgment is the actual document that grants you the divorce. A lot of people call it the divorce decree, but in the state of Florida, they call it final judgment of dissolution of marriage. And if you look at the top, the uncontested is basically you're saying we're not contesting it, we've both agreed to it. So this is the form the court will sign and give back to you. See, it's saying that the settlement agreement has been, parenting plan has been attached, and the court will sign it, and they'll send you a copy. But let's say you don't agree. If you don't agree, you don't sign the marital settlement agreement, you don't sign the parenting plan, then the court will enter this final judgment. And as you can see on the bottom, there is no uncontested. So this will be only entered after a final hearing, what we call a trial. So what would happen is the court will hold a trial without a jury, and the court will listen to your evidence, the other party's evidence, any document you have, any witnesses you have, and the court will decide all the issues regarding the marriage. They will grant the divorce. How are the assets going to be divided? What are the assets? How are they going to be divided? The petitioner gets something, the respondent gets something. So the court will decide all that for you. Same thing with any type of assets or liabilities, debts. So the court say, okay, the petitioner, you are responsible for these debts and the responsible for these debts. So the court is going to do that after all the testimony has been heard. So the court will decide who gets what. And if there's a home that you both own, who's going to decide who's going to get to use it, and or if you get to keep it. So the court will decide that. Parenting plan. The court will decide whether, if you can agree, then after listening to all the evidence, they'll decide who's parental responsibility and who gets child support, who gets time sharing, and they will do their own parenting plan, and the court will attach it. And then if there's going to be alimony and anything else that is involved in the divorce action, the court will fill out. So you don't fill any of this out, you just leave it blank, and then the court will fill it out after hearing all the evidence. And in the end, the court will sign it, how child support is going to be paid, if you look at it, and if there's attorney's fees, and the court will sign it, and they will send you this after the hearing and after a court has decided. Sometimes, rather than using this form, the court may issue their own final judgment, and that will look totally different than this form. So be prepared to receive either one if you go to a final hearing and you decide. So you've done that and you've received that, so you're good. So final form we have in this packet is the parenting plan. Again, this is similar to the marital settlement agreement. If you can't agree on it, you can submit it on your own behalf, but you can't submit it as an agreement. I would always recommend that if you think the other party is not going to agree and not going to take the effort to it, I would fill this form out and still submit it so that the court has something to look at. So if he's like, nah, he or she are like, I'm not agreeing to anything, I should get 100%, you should get 0 time, that's really unreasonable. And you never know, they might not even fill out any form. So for the court to have a sample or one that's prepared already, it's good for you to submit it on your own. But it's ultimately up to you whether you want to submit it. And I highly recommend you submit it. So I'm just going to briefly go over it because it's ultimately up to you whether you use it. And this is very detailed. So you want to take some time, and you have to take many things into consideration when you fill this form out. So be prepared to decide, you have to think about who are they going to spend their birthday with? How about President's Day, Thanksgiving, Christmas, spring break, summer break, all that fun stuff? You're going to have to decide who gets what time. So you have to decide on that on your own, especially if the other party is not willing to negotiate with you. So there are several ways you could submit it. You could say parenting plan is with the agreement, meaning you both agreed, or I'm sending it as a proposed agreement and write your name. And if the court is the one that's going to sign it, then the court will check this. This doesn't apply to you. So you're going to check either one or two. So one is if you both agree and you both have to sign it. There's a signing page for both of you at the end. Or you could say, you know what, he or she's not agreeing, but I'm going to set it on my own behalf. And so this is what you're going to check. And at this point, you're going to leave this section blank because you won't know until you get towards the end, because the court is the one that's going to decide. So we're going to go over each section. So because this is supposed to be a holistic form, you take ideally you have a copy and the other party has a copy of this plan, so that you have something in writing to fall back on if you can't agree. So what the court requires is you to fill out all the information regarding you, with your name, your address, and anything else, email, contact, and the respondent, their name, and anything else, address, etc. in there. Then you have to list all the children that are common to both. And if you have more than 5, you could add additional pages. And jurisdiction. Remember, we were going over the Uniform Child Custody Jurisdiction and Enforcement Act? You're saying that the state of Florida is the home state for the purposes of this. So again, they can't go to Georgia and try and change it without the court in Florida being aware of it. So that's what jurisdiction is. And section 4 is parental responsibility. Remember, we talked about it briefly. This is where you're going to say who gets to decide what the child does. You could have it shared, or you could have it shared with certain things, or sole. So you have to make sure you make the right decision. And you have to get explanation of why. So that's what responsibility. And then day-to-day, extracurricular activity, who gets to decide what? And if there's extra costs, who's going to pay for it? So you have to decide how that is done. And information sharing. Generally, it's important that you and your spouse contact each other or have contact if there's a reason to contact about the child. You may hate each other, but you have this child in common, so you have to be available to the other party so that you get information from the school, from the doctors, etc. So you have to make sure you share. Scheduling. So this parenting plan assumes that the child or the children are quote unquote of school age, only because this is supposed to last until the day they graduate high school. So even though you may have your child is only 6 months old, you have to assume they're in school and they're going to follow the school schedule. So what this says, school calendar. So most of the time, I would say most schools in Florida start in August. So before August, you want to know which school calendar you're going to follow. And you could follow the oldest child, the youngest child, or the county. And I think the county is the easiest because if you have several children, let's say 3 children in 3 different schools, which one are you going to decide? County is always the easiest, but it's ultimately up to you to see which one you want to decide. Or the specific school. Again, if you have 3 different schools, the school is not very convenient. Then academic break, this is to say whatever holiday or breaks that you have, you're going to follow the school schedule. And then if there's any changes in the school schedule, what are you going to do? Which parent gets to make changes, etc., etc. So you got to decide what you want to do. Time sharing. This is important. In the past, it was called custody and visitation, but now it's called time sharing. So basically, you have to come up with a plan where each minute of time is accounted for the children. So if you're doing the quote-unquote traditional schedule where the mother gets the child Monday to Friday and the father gets every other weekend, then you'd have to say mother gets the child every Monday, Monday through Friday from 6 a.m. to 10 p.m. And then the father gets every other weekend. So you have to schedule it. You have to come up with a schedule. That's just daily schedule. And then if there's different schedule for different children, you're going to have to write that. So what do you do on a holiday? Are you going to say it's going to be the same or no holiday? Or you're going to do it based on what the parties agrees? My recommendation is, if you have a very good relationship with your spouse and you're reasonable, this is always easy, because then you don't have to have every minute accounted for. So then you could say, you know what, we get along, we're adults here, we don't have to have something in writing to make us follow it. However, if you can't get along, then you have to have a specific written schedule. Do you see this? Mother's Day, Father's Day, President's, MLK, Easter. So you have to come up with a plan for each of these days. Do you do it where it alternates, or do you do it every year? So you have to come up with a plan that you want, that works best for the children, not for you, but for the children. So then that's just regular holiday. So what happens if the holiday falls on your schedule? How are you going to handle it? Who gets what? So you have to decide how you're going to do that. So what do you do during winter break? This is usually Christmas break. How are you going to determine who gets what days? There are some parents that like Christmas, New Year's, Hanukkah, Kwanzaa. How are you going to decide which parent gets what? Oftentimes, the court will break it half. So one parent gets them half day Christmas Day, other parent gets them second half Christmas Day. So you have to decide what works best for you. Spring break is usually a week, almost 2 weeks in some places. How are you going to decide? Is there going to be a regular schedule, or are you going to come up with a different schedule? Are you going to alternate, or are you going to have it the same every year? Summer break is another long, you have almost 2-3 months. So how are you going to do it? Are you going to do the regular schedule, or are you going to have some parents switch, or you could do it another way? Whatever works for you, you're going to do that. Once you decide how the time sharing is going to be, you have to decide how many number of days the mother gets and how many number of days the father gets or the other spouse gets. So then you decide 180 days for the mother, 185 days for the father. So then you have to equal 365 days. Okay? So then that decides. And then transportation. Who's paying? Who's going to transport? Where do they live? How far do they have to drive? And if you have to go a long way, how much? Who's going to pay for gas? So you have to decide on that. Where are you going to exchange the kids? If you get along, you could pick them up at each other's house. If you don't get along, are you going to meet at the doctor's office, police office, McDonald's, a local place that everyone is aware of? That's what you have to decide. And then transportation costs. Gas gets expensive sometimes. So who's going to pay if you have to travel from Inverness all the way to Crystal River, which is about 45 minutes? Or you're going from Orlando to Osceola County. That's a long, Kissimmee. Let's say Orlando to Kissimmee. That's a long drive. Who's going to pay for it? So you have to decide that. Foreign and out-of-state travel. This is if you have time sharing time. Usually if it's a long duration. You have family out of state. You have family in a different country. How are you going to handle it if you have to take your child out of the country? That's a little bit easier than what are you going to do if you're going out of the state. State is, easy. You're going from Florida to Georgia, Florida to Alabama. You could say, hey, I'm going to Alabama to visit my relatives. How do you want notice before you travel? How much notice do you want? What if you're going out of country? Country is a little bit more difficult because you have to get a passport. However, what if the child already has a passport? How are you going to ensure that the child will be returned home and then you get your time sharing? So you have to come up with how are you going to do all that. So make sure you do that. And education. Remember we were talking about parental responsibility. Who gets to decide what school? Maybe one parent wants to send it to a private school. Who's going to pay? One parent wants to send them to public school. Who's going to pay? If there's long travel, they want to send them to a school in a different county because they have better education and they could get a waiver. How are you going to take the child? Who's going to pay and who's going to decide? That's something you have to come up with as well. And then designation for other legal purposes. Some states still use the term custody and visitation. So one parent has custody, the other parent has visitation. In Florida, we don't use that term anymore. So to clarify to other courts, you have to decide which parent has majority of the time and they're considered quote unquote primary. And that's what you have to decide. So it usually applies to the parent that has more time than the other. So you have to decide on that. Communication. How are you going to communicate between the parents? Are you going to do in person only, telephone, letter, email? So you have to check what you want to do. What about between parent and children? How are you going to do it? You're going to do it by phone, email? Is there going to be limitation? Obviously, you don't want to interrupt the other parent's visitation. So when your children are visiting you, you don't want the other parent calling you every 5 minutes, every hour to see what's going on. But what if their parents are, I read them a story every night before they go to bed. Can I do that while they're visiting the other parent? You have to come up with a plan and think of that. What if you have to have video and it costs extra money? Who's going to pay for it? So you have to decide there. And then childcare. So who's going to decide who gets to watch the children, especially if they're younger children that need nannies or babysitters? Who gets to decide? What if I'm supposed to have visit with my child, but I have to go into work? So what's going to happen? You could say, hey, do you want to take your child back and I'll make it up some other time? Who gets to decide that? So you have to decide how you want to handle that. And the last few sections deals with modification. So if you have any changes or modification, temporary they call it, you don't have to go back to court and get a court order. You could both say, hey, do you mind if I switch from this Friday to next Friday? And if the other party's like, yeah, that's fine, I'm good with that, you could do it without going to a court order. But if you say, hey, do you mind switching it to Friday, and the other parent's like, no, I already made plans, so I can't switch it, then you have to refer to this written parenting plan. So this is why each of you gets a copy of the parenting plan, so you know how to use it as default. And relocation. Relocation is very important because state of Florida has one of the most restrictive relocation rules. If you move outside of the living area more than 50, 60 miles, you have to get a court order. So if you live in Orlando and you want to move to Miami with the child, you have to get a court order to move it. And you have to file a motion with the court, and that's the statute that they provide, and it gives you the procedure. You have to send a notice to the other party. If the other party objects, you have the hearing, and the court looks at the best interest of the child. Not whether you get a great job, but what's in the best interest of the child before they decide whether they'll let you move. So you have to take that into consideration. Let's say the other party agrees. You have to get that in writing, and then you get a court order allowing you to move. So you have to consider all that before you relocate. And disputes and conflict. If you have any disputes, you could always do it informally where you don't have to come before the court. Mediation is always good. Or a parenting coordinator. Those two are always good. And you could usually find them and do it outside of the court system. However, if you can't agree, you have to come back to the court and have the court change it. So those are all the issues that you have. And again, as I say, if you are the one seeking it, you could sign it and get it notarized and file it without the other party. However, if you want to send it as an agreement, you both have to sign it. Make sure you both sign it if you want to send it in with a marital settlement agreement and a parenting plan. So those are all the forms you need to file a divorce. So the next section that we're going to go over is service of process.